Hello, welcome to the League of Women Voters Forum for Magistrate Candidates for District 05-02-19 that covers the municipalities of Mount Lebanon and Dormont. My name is Maureen Grossider, and I'm the president of the League of Women Voters of Greater Pittsburgh, and I'm going to be the moderator for this forum. The League of Women Voters is a nonpartisan organization that neither supports nor opposes any candidate or political party. The League focuses on facilitating informed and active participation by citizens in government. This forum is being conducted by teleconference and will be streamed in its entirety on the League's Facebook page on Thursday, October 21st, 2021 at 9 p.m. It will also be posted on the League's YouTube page. Information on how to access both the Facebook page and the YouTube page site may be found on our website, which is www.lwvpgh.org. The Magistrate District Judge represents the first rung in Pennsylvania's legal system and is responsible for dealing with a variety of offenses ranging from traffic violations, theft, truancy, landlord-tenant disputes, to more serious issues like protection from abuse orders or significant crimes that must be sent to the Court of Common Pleas. They also decide when to authorize arrest and search warrants and can perform marriages. The term of office is 6 years, and judges in this position do run for re-election. A few specifics regarding today's forum. We're going to have about 60 minutes to ask questions, and each candidate will give a closing statement. A coin was tossed earlier by the League of Women Voters Committee to determine the order in which the candidates will speak. Each candidate will have a chance to answer each question, with each person having 1.5 minutes to respond. There will be no time given for rebuttals. If a candidate wishes to respond to another candidate's statements, he or she will need to use time from the answer to the next question. I'll be asking the questions in a rotating manner so that each candidate will have the chance to be the first to answer a question. Questions have been gathered from a variety of sources and have been reviewed for relevance to the position being sought, and also for duplication, clarity, and civility. Candidate answers will be timed, and candidates will be advised when their time has expired, although you will be allowed to complete your sentence. Please remember, to those in the audience, that these candidates are your friends and your neighbors who have stepped forward to serve their community. This evening, I'd like to introduce the candidates. Hillary Wheatley Taylor is our Democratic candidate. Dwayne Fisher is our Republican candidate, and Olga Salvatore Manning is our Independent Justice Party candidate. And based on the drawing of straws, the first question will go this evening to Olga Salvatore Manning. Please tell us about your qualifications and why you're running for this office.
This office is very important. As it's been said, the Magisterial District is the first rung of pretty much anyone that enters into the legal system. I've been practicing for over 15 years and represented thousands of clients. I am a criminal defense attorney, and I have represented clients from summaries to major felonies. As a family division attorney, I've represented clients in divorces, support, child support, custody, PFAs, equitable distribution, and the like. I've covered juvenile delinquency, and I've represented clients in juvenile dependency. I've done hundreds and hundreds of bail and detainer hearings. I've represented thousands of clients. I have experience in all matters that pretty much appear in front of the Magisterial District Judge and would hit the ground running if elected.
Thank you for your response. Now we're going to go use the same question, and that will go to Dwayne Fisher at this point. Mr. Fisher.
Thank you, Maureen, and thank you, Olga. I looked back at our previous one and we only had 90 seconds to respond, so I'm not too worried about time, and I'm glad we didn't try to fill all 90 seconds there, nor will I. With that being said, my qualifications for this position, I have been a resident of Mount Lebanon for 23 years. I worked in Mount Lebanon for the police department for 20 years. I have an extensive history in public service and public safety, over 33 years total, starting out as a EMT and EMS and working my way through. The reason I'm a good candidate is because I've practiced my 20 years in that courtroom. I've prosecuted cases. I've prepared PFAs to be presented. I've prepared search warrants. As a police supervisor, I would review these things before they got to the judge to make sure they were within the scope of the law and would get through without any type of hitch. My position has always been to help people, to be out in the public. I have been in charge of our community outreach program when I was with the department, and I continue to work to help people solve problems even now in my new position beyond Mount Lebanon. My goal is to get back here to home and continue to serve this community.
Thank you, Mr. Fisher. Now the same question to Hillary Wheatley Taylor.
Thank you, Maureen. I have 19 years of legal experience, both in contracts and transactional work and in court representing individuals, businesses, property developers, and government agencies. Much of my work in the last 14 years has been before magistrates. I've served as a court-appointed arbitrator, trained and served as a housing court mediator, and volunteer as a housing court pro bono attorney. Much of the work that magistrates do is in civil litigation and contract interpretation, including landlord-tenant matters, code enforcement, and neighbor disputes. I know many people think that the magistrate is a sexy job full of criminal casework, but it really is a tiny but obviously important part of the job. It's a job for a detailed-oriented person who knows how to read, interpret, and apply the law and can see the nuance in a case and in the participant's circumstances. Throughout my career, I've come to see what an important role courts play in the fabric of our communities, our county, and our region. And as I've come to love Mount Lebanon and call it home and its surrounding communities, I came to realize I could be a person who fills this important role in the community. I'm running because I decided it was time that our courts reflect the spirits and hopes of its citizens, and because I want our Magisterial District Court to be a place of trust, equity, and community-focused justice.
Thank you. Now the second question, we're going to start with Dwayne Fisher. How do you propose to handle truancy cases while balancing the needs of both students and school district?
Thank you, Maureen. Truancy continues to be an issue that we have to face in Mount Lebanon. When I worked with the police department, we developed a grant program called Strike to strategically target addressing the concerns of truancy. What we did is we reached out to the community. We worked with the school district, with the magistrate, in order to develop a plan where we could meet with the teachers, meet with the counselors, meet with the parents, and find out if there are underlying issues that are causing this truancy, that it's not just something that they don't want to go to school, that there are traumas or issues at home that may be affecting them, whether it be a housing issue, a family issue, a food issue. There's all types of things that can create an issue that results in truancy. So my goal would be to, again, foster that collaborative approach that we've used in the past, try to target having our hearings at the school district, perhaps after hours or even before school, to help minimize the impact on the family and the student while still trying to address the issue to get them back in school and get them the education they deserve.
Thank you. The same question now is going to Hillary Wheatley Taylor.
I would be a partner in solving the problem that brings the student before the court. A magistrate's role in dealing with truancy referral is to screen it for compliance with the Truancy Act, ensure the school has cited only the child or the parent, but not both, confirm the school has already held the required school attendance improvement conference. If the referral has been properly made, it is the magistrate's role to hold the school to its burden to prove beyond a reasonable doubt that the child is habitually truant without justification. It's that last part, without justification, where a magistrate has an important role to play. In determining whether the absences are without justification, I would consider whether the child was or needs to be evaluated for an IEP or 504 plan, whether there are other unmet needs of the child or family causing the absences, or whether the child is experiencing bullying or harassment leading to missed school. However, it's also vastly important that magistrates understand that all penalties for truancy are discretionary, whether that be fines or community service or a school attendance program. Magistrates have complete discretion in how to best address both the needs of the school to enforce its attendance requirements with the particular needs of the child and family. While fines are an option, fines should only be imposed where there is an ability to pay hearing held to determine the financial circumstances of the family. And lastly, I would ensure that court stays in court at the courthouse and not take place in the school building.
Thank you. The same question now for Olga Salvatore Manning.
I think the issue of truancy, the first and primary focus should be what is the basis for the truant act, if in fact there is one. I think you need to investigate the household. I think you need to investigate what issues the child may be suffering from. Like Dwayne mentioned, it might be bullying at school. It could be all kinds of environmental factors. And I think that that's the primary place to begin in order to determine where to go in with any particular truancy case. I believe there are many stakeholders in the neighborhood. There are school outreach programs. There is the police community outreach. There is the court system. There are agencies available throughout Allegheny County in order to assist families if they are the primary reason for the truancy, or if there may be drug or mental health issues with it. There are agencies that can assist so that the child doesn't miss school and we can ensure that the child gets back to school. But we also have to protect the child and make sure that the best interests are protected, and education is primary focus, but also their own safety. So I believe that the initial step must be trying to find out and figure out what the basis for the truant act is.
Thank you. Now, the next question, we're going to start with Hillary Wheatley Taylor. Magistrate judges are authorized to set bail and to set the terms of release. People can be released on their own recognizance, cash bail, electronic monitoring. What factors would you consider in granting and/or setting bail for people in your courtroom?
First of all, I would remember that cash bail is only one tool in a magistrate's tool belt, but it's never mandated. And I am against the use of cash bail. No one's freedom should be tied to the balance in their bank account. In a circumstance where a defendant has been determined to be eligible for bail, I would consider the seriousness of the offense, the past criminal history, and the likelihood of the defendant's appearance for his or her next court date in making a bail determination. However, no one deemed safe enough to be free while awaiting trial should spend a single night in the Allegheny County Jail because they are too poor to buy their freedom. I will instead rely on all the other tools in my bail tool belt while ensuring the public is protected.
Thank you. The same question now goes to Olga Salvatore Manning. Do you need me to repeat it?
No,
should have
thank
asked.
you.
Okay.
Thank you. Well, bail is never set as a punishment. It cannot be a punishment. Bail is only set to ensure the defendant's further appearance at court proceedings. I think in order to assess a particular situation, you have to look at the criminal charges that are alleged and assessed at the time. You have to look at the past behavior. You have to look at the defendant's possible failures to appear in other circumstances. You just have to take the entire picture of what is in the affidavit that led to the arrest. Bail, again, is not punishment. It's just to ensure the person's presence at trial. So each case needs to be individually assessed. And I believe that in invoking the assistance of pretrial services with the risk assessment tool in order to make the determination that the defendant is not a danger to the community, danger to the victim, danger to anyone else, then bail should either own recognizance, or if there is some sort of fear that the defendant may flee, you could do electronic monitoring. Therefore, he or she can go to school, can continue to work. But again, it is not punishment. It is just merely to ensure the defendant's appearance at further court proceedings.
Thank you. Now the same question to Dwayne Fisher.
Well, to invoke Hillary's response from the May one, I'll use ditto and just say that was a good answer. But I think it's a combination of the two opponents here that need to be addressed. I mean, Rule 523 clearly addresses the 10 different items you look at as far as addressing whether or not or what factors you should consider when you're setting bond. I do think there is a time for cash bond. I don't think that it should be used at random or just at willy-nilly, if you will. I think it needs to be used very carefully when the person is deemed to be a threat to the public. And now I know we always want to do ROR as much as possible. The electronic monitoring is another great intermediate step, but there are at times when you're going to have to look at when part of setting bail is consideration to the safety of the public and the victim. And there are times when those factors are going to weigh in and a person needs to be held and a bond needs to be set. And I agree with Hillary 100%. It shouldn't be tied to your bank account. That's prejudicial. It should be tied to your offense. It should be tied to your likeliness to reappear, the potential safety issues the community faces if you're out in the community still, and the chance of recidivism before you get to court. These are the things that need to be considered.
Thank you. Now, the next question, we will start with Olga Salvatore Manning. Because magisterial judges preside in communities where they know some of the people who appear before them, how will you remain objective and handle potential conflicts of interest with those you know personally who may appear before you?
Well, the first thing I would do if somebody appeared before me that I had a relationship with is I would disclose it to all parties in the courtroom. And a lot of times, in a lot of cases, I have seen the judges will do that. And if none of the parties object, then the proceeding can continue. Under no circumstances, if I had a significant relationship with anyone in the community, would I preside over the case. I would recuse so as to not show any sense of impropriety. Other than that, the conflicts do exist. Everybody is involved in the community. We all participate in things in Mount Lebanon and Dormont. So it is going to happen that you run across someone that you know. But I think that just knowing somebody isn't reason for recusal. And I don't think it automatically should invoke a conflict of interest. But the three of us are pretty smart. And I think that we would know whether or not a conflict exists and if we could sort of be swayed one way or the other because of the relationship.
Thank you. The same question now to Dwayne Fisher.
Thank you, Maureen. And I would have to echo Olga's comments on that. I've been deep-seated in this community, both Dormont and Mount Lebanon, with my years of service here. I'm going to know a lot of people. Blaze knew a lot of people. He was still able to do his job. And I think the disclosure is key if there's any type of relationship, but you still have to do your job. You can't be recusing yourself from everybody that you know in this town. Frankly, you're not going to get elected if you don't know people in this town. So if that's what they're concerned about, maybe they should consider appointing magisterial district judges. But the thing is, as Olga said, we're intelligent people. We're going to put the cards out on the table. If there's a concern, however slight, then you would recuse yourself. But even as a police officer, living here, one of the few that lived in town, working here, going out here, just having my entire life here with family here, I always had to encounter people. I've had to deal with people that were police officers that I knew and discipline them. And that is a matter of just staying objective and doing your job. That's what this is about, doing your job, whether you have relationships or not. But if they're that heavy of a concern, then you should step aside once you've disclosed everything to the parties involved.
Thank you. The same question now to Hillary Wheatley Taylor.
First and foremost, I would comply with the rules of judicial conduct and the rules of professional conduct governing lawyers in conflicts of interest in Pennsylvania, which would require us to disclose any known or perceived conflict and recuse ourselves from cases where that conflict may give parties less trust in the impartiality of the court. My experience as a court participant has been that judges tend to disclose a potential conflict, tell the litigants they believe they can be impartial, and then place the burden on one of the parties to request recusal. That's a terribly uncomfortable position to be in as a litigant or lawyer in a courtroom. Rather, I would, on my own, recuse myself when a conflict of interest arises, so as to give the community trust in the impartiality of the court. Evaluating conflicts of interest is a familiar practice for me as a lawyer, engaging new clients to determine whether or not I have a conflict. And that practice and that evaluation would not change if I were elected. Like Dwayne and Olga both referenced, we're members of this community, and the reason we have to live in this community is because they want the judges to be members of the community presiding over community courts. So it does place magistrates in a difficult position of having to preside over cases involving our friends and our neighbors and our business associates. But like Olga and Dwayne both said, we're all smart people, and I think we're intelligent enough and capable enough to recognize the difference between a real conflict that requires recusal and one that does not.
Thank you. Now, the next question will go to Dwayne Fisher to start. And the question is, some people believe law enforcement may have undue influence in the court system. How would you balance the court's relationship with law enforcement and the rights of defendants?
Wow, Maureen, that's ironic that the police officer gets that question, isn't it?
Well,
Anyhow,
we're gonna rotate it.
No, that's good. But it's a fair question, and I think there is concern that way because there's continued interaction between the judiciary and law enforcement, and so there is a fair concern. But I think, as I brought up in May, if you poll the police, not all of them are going to like me because I held police accountable. I investigated police officers when they did misconduct. Sometimes they didn't like the fact I corrected their work when they submitted the stuff for PFAs, for search warrants, for charges. And I said, that wasn't good enough. We don't have enough to file. You need to do a better job at policing if you want this to proceed. So I think in me, they will see a police executive that has held police accountable, that is not afraid to hold them to task and to make them do the job the right way in order to protect the interests of the individuals in the community as general, as well as the police.
Thank you. The same question now is going to Hillary Wheatley Taylor.
Thank you. I value the very important role that law enforcement plays in our communities. However, the constitutional rights of defendants who have been charged with a crime, who are presumed innocent, are of the utmost importance and are the bedrock of our constitutional democracy. At the same time, the role of law enforcement is a critical one to our justice system. The magistrate's role is not that of a law enforcement officer. Magistrates, as part of the judicial branch of government, are tasked with evaluating the facts of a case, interpreting the applicable law, and making a ruling within the bounds of their judicial discretion. It's important that magistrates hold each party to their burden of proof and evaluate the credibility of each witness independent of their job title or role in the proceedings. And that's the kind of magistrate I endeavor to be.
Thank you. The same question now going to Olga Salvatore Manning.
Well, I'm not intimidated by pretty much anybody. So the balance of power, if I were elected, would be even. Every participant in the Magisterial District Judge's office would be treated fairly, evenly, and equally. Cases are fact-driven. Cases appear before us, and it is our job as magisterial district judges to review the evidence and to review what is apparent and apply the law as you see fit. I've been doing criminal defense for a really, really long time, and so my relationship with the police is pretty good. I'm not influenced. I don't believe that they have extra powers that other participants don't. Everybody comes in with the presumption of innocence, and you have to take the cases for what they are individually. You have to judge them. I really do not believe that one party has any extra influence over any other, and they certainly wouldn't in my magisterial district.
Thank you. Okay, now the next question, we're going to start with Hillary Wheatley Taylor. Many citizens coming before magisterial judges for landlord-tenant disputes or requesting a protection from abuse order or resolution of a money claim or other situations may lack access to legal assistance or representation. What steps would you take to address that situation?
Well, in a situation where they're entitled to counsel, I would ensure they've been advised of their right and have the opportunity to seek counsel before proceeding. In situations where there isn't a legal right to counsel and legal services are not available, I would take as much time during the hearing as necessary to ensure the participants understand the proceeding, understand their rights, understand the consequences of the choices they may make during the proceeding, and understand their rights, duties, and obligations following entry of a decision. Whether that's to connect a participant with legal services that may be available and continuing the case to allow time to seek those services, or continuing a case to provide translation services to make sure that participants understand what's being said and what's taking place in the hearing. I would schedule the hearings in a way to make sure I have adequate time to give the participants a fair and adequate hearing before the court.
Thank you. The same question now goes to Olga Salvatore Manning.
I believe everybody is entitled to representation, but like Hillary said, there are certain cases that it is mandated. What I would do if there was a pro se litigant is I would speak to them, explain to them exactly what the proceedings are going to be, how the evidence has to be presented, and give them the opportunity to seek counsel if they so choose. As far as a criminal defendant is concerned, I would also, if they have not been able to go and apply at the public defender's office for their representation, I would give them time in order to allow them to do so. If they choose not to, then I would explain everything that is going on, every piece of paper that they are signing, every right that they are either waiving or not waiving, what they're entitled to and what they're not entitled to. A lot of times during the course of my professional career, if I have been in magisterial districts as a criminal defense attorney, and I have come upon situations where there were defendants that were unrepresented, I would get up and I would come up and I would take them aside and I would explain things to them just automatically and make sure that they weren't making decisions that were uninformed and that could have serious consequences later on. So I do believe everybody deserves representation, but that is not a luxury that everybody has. So I think it is our job as magisterial district judges to provide them with all the information that they need in order to decide for themselves if they want to proceed or not.
Thank you. The same question now is going to Dwayne Fisher.
Thank you, Maureen. And I would have to echo a lot of what both the other candidates have said so far. It's apparent that there's no need to rush to justice. That's the thing. Take your time, explain things to people, give them a chance to understand, use active listening to make sure that they are understanding and getting the feedback that you're giving them. I've seen already where the magistrate in Blaze's courtroom has reached out to an attorney that's been in the courtroom and asked them to help somebody. That's the type of relationship you need to have. That's the type of relationship I have with a lot of attorneys, and I think that will just continue into the magistrate's office. I apologize to Judge Arnone for saying magistrate. I'll do my best to continue with magisterial district justice. I know that upsets him if he watches this. So the key is you have to take your time. You have to focus, give them the opportunity. If you have to give them a continuance, give them a continuance. There's lots of services out there, more and more every day. Community law services, family law services, outreach programs from the state and federal governments. There's no reason to push someone into a situation where they have to make a decision that is too quick or too ill-informed for their best interest. So again, spell things out, let them make the decision, but I still think it's best to err on the side of caution and give them the time to look into the matter a little bit more and then bring it back to the court to be addressed.
Thank you. Now, this next question, we're going to start with Olga Salvatore Manning. If you become aware of unethical conduct on the part of an attorney or law enforcement official in a case where you are presiding, what steps would you take to address it?
Well, we are guided by the rules of professional conduct and the canons once elected. If there's something that is unethical on behalf of an attorney and that appears in front of me, a police officer or anything else, I would not hesitate to report that person and have them separated from the case, make sure that the DA doesn't want to refile if there's an issue with that. There is no need to ignore this. There is no place for that kind of behavior in any magisterial district court or any court at all. I think the integrity of the office needs to be maintained at all times. We are not there to cover up for other people. We are there to be professionals. We are there to follow the rules. They're there for a reason. So therefore, any unethical conduct that comes before me that I know will be reported. It will not be tolerated because we cannot afford the public's distrust in the court system. I mean, it's already up at issue as it is. And so therefore, these things need to be brought to the limelight, need to be pushed right forward, and so that the public trusts us and we can continue to run the judicial system efficiently and effectively and regain the trust that's been lost.
Thank you. The same question now is going to Dwayne Fisher.
Thank you, Maureen. And again, to echo Olga's comments, you cannot tolerate this type of behavior in the courtroom, be it from an attorney, be it from a law enforcement official. There's avenues to make these reports, go through the State Ethics Commission, if need be, the Municipal Police Officers Education and Training Commission, if it's something that warrants the level where they need to be decertified. If it's something that comes to light, like the Brady rule, where they're not going to be trustworthy, then these type of things have to be addressed immediately, openly, and to protect the sanctity of the courtroom so that people have faith that we are being transparent, that we're being just and fair and giving them their day in court, and nobody is getting favors, nobody is cutting corners, the rules are being followed, and everybody gets what they deserve fairly at their time at the court.
Thank you. The same question now is going to Hillary Wheatley Taylor.
At the risk of just saying ditto, I will expand on it just briefly to say that in addition to reporting it to the Pennsylvania Disciplinary Board in the case of an attorney, or to the law enforcement officer's employee in the case of a law enforcement officer, I would also raise it during the proceeding and take whatever action is necessary in the moment to ensure the fairness of that particular proceeding. We can't let unethical behavior go unchecked in court. And finally, that conduct, to the extent it takes place in my presence, would play a role in future credibility determinations of that participant in court.
Thank you. Now, the next question, we're going to start with Dwayne Fisher. Pretrial services and diversionary programs are used in some courts. Do you have experience working with those programs? How about alternative sentencing programs? And are you supportive or not? Please explain your position.
Thank you, Maureen. I've had limited experience with working with those type of programs as a police officer. We have had some introduction to that as far as being able to use the crisis intervention training, or CIT, where we were able to get people into diversionary programs to address a crisis rather than try to arrest our way out of a situation. Nobody wants to see someone go to jail because an officer is incompetent or just not aware of the services that are out there. There are so many mental health courts or programs, or veterans court or other programs, housing that you can look for as far as issues when it comes to landlord tenant. There's so many different programs. I will tell you candidly, community service has not worked out too well right this day and age with liability. A lot of people are reluctant, and people may tout the idea of community service, but it is very difficult to get people that are willing to allow people to come, even at churches and things, due to the liability. So I think it's important that we continue to focus on federal and state programs that allow for diversion, and programs that allow us to address the specific needs or issues that people are facing and get them into those programs rather than arrest our way out of it, rather than populate our jails with people who could be better served with a social service program.
Thank you. The same question now goes to Hillary Wheatley Taylor.
Well, I don't have any specific work experience with pretrial services and diversionary programs in the criminal side of the justice system. I do support alternative sentencing programs, especially ones that are truly diversionary. Requiring a guilty plea to enter a diversionary program still leaves a defendant with a criminal record that must be disclosed on school, housing, job, and military applications. That can be a barrier to someone's future. I'd like to see our court system create and implement pre-plea diversionary programs. With all that we have seen in the news about the conditions of the Allegheny County Jail recently, and from my conversations with men and women who have spent time in our jail, I fully support programs that divert eligible defendants from time spent there. And on the civil side, I do believe there's an opportunity for programs that divert certain cases from being sent up to the Court of Common Pleas, including landlord-tenant mediation programs that have been developed and are being used in other districts in the county. And I'd like to be able to bring such a program to our district.
Thank you. The same question now to Olga Salvatore Manning.
There are very many diversionary programs that I have extensive experience in. There's even one in, Dwayne mentioned Judge Arnone's, there's a retail theft class. So that sometimes these defendants get into situations, maybe it's drug or maybe it's mental health, but it's a minimal offense. It's a retail theft. So therefore, as opposed to holding it and carrying it over to go up to common pleas, they give them a diversionary program and they send them to, it's called retail theft school. As far as my experience with mental health issues and addiction issues, there are very many pretrial services that are available to defendants that are diversion in the sense that they don't go to the jail. In the interim, they're released to rehab, inpatient rehab only, or they're released to a mental health treatment program. This is all pretrial diversionary stuff before they can deal with their issue and get in before a common pleas judge. The diversionary programs offered in Allegheny County are vast, and there are lots of opportunities at this level to familiarize yourself with them, because then you do not flood the common pleas court with minor infractions for people, but you actually allow them to get help prior to going up to common pleas court. So I think there are programs that we all need to be aware of and take advantage of.
Thank you. Now, and with this next question, we're going to start with Hillary Wheatley Taylor. Many people don't understand the court system. Do judges have an obligation to improve public understanding of the courts? And if yes, how would you do that?
Yes, I think judges can play an important role in community education about the procedures and the role the courts play in the justice system. I've attended several continuing legal education seminars taught by magisterial district judges and judges at the Court of Common Pleas and federal and state appellate court level. And while those are, geared towards educating lawyers on certain topics, there's no reason why judges couldn't participate in community-based education programs to inform the community on a particular topic, so long as we comply with the rules that prohibit us from commenting or stating an opinion or position on any particular kind of case or how the judge might rule. But to the extent as an elected official in the community, we can help bring back some trust and reliability and faith in the system, I absolutely believe we have a duty to do so.
Thank you. That same question now goes to Olga Salvatore Manning.
I don't think there's a mandate that judges or any judicial officer is obligated to inform the public, but I do believe that it is a good idea. If elected, I would love to have an open door policy. I would love to put a suggestion box in the lobby of the waiting room of the courtroom, so that constituents can put suggestions in there. Maybe no cattle calls. Maybe can you stagger the hearings, or can we do them at different times, and just actually involve the public in the running of the office, because we are public servants. We are there to serve them. They are our clients. And in order to make them more comfortable and to make sure that they have faith in what we do, they need to have a say. I would like to go to the schools. I would like to continue what Judge La Rotonda did and keep educating the kids about the process, and hopefully divert them from actually ever wanting to engage in it. I would love to just keep going around in the neighborhood, and obviously just be open, be transparent, just be clear. And anybody that has any questions, come on in, ask. It's not a secret society. It is an open courtroom. It is open to the public, and anyone can come in at any time and ask whatever they need to ask to get more informed.
Thank you. The same question now to Dwayne Fisher.
Well, I can't jump on that bandwagon quick enough with Olga about getting rid of that cattle call. That is something we all complained about in the primary, and it's the sooner the better, regardless of which of us three gets in. Hopefully, one of us will address that issue and stop it. It's annoying on everybody's level. But judges don't have a legal obligation per se, but I think they do have a moral obligation by the very nature of their office to help educate the community. Again, we would continue with the programs that Officer Laratunda, Judge Laratunda did, where he would go into the schools with the civics, with the law classes, help them understand the process. We continue with what I had done, just as he had done with the Citizens Police Academy, the Citizens Academy, that we had worked out as outreach programs, participating as board members as far as the, like he did with outreach. I think there's a lot of opportunity for the judge to work beyond the courtroom and facilitate the understanding, facilitate those relationships, get people to understand what we're there to do, what we can do, and how we can bring justice and the best results for individuals and the community at the same time.
Thank you. Now, this next question, we're going to start with Olga Salvatore Manning. What standard of proof is necessary in magisterial court to bind a person over for trial in common pleas criminal court?
Well, a standard of proof at a preliminary hearing is prima facie. And as I was practicing for 15 years, trying to explain this level, which is so low, to a client has been extremely difficult. So in layman's term, you have to prove that a crime was committed and that the defendant sort of kind of did it. There's no defense. You cannot present a defense. It is the most minimal level of burden. It's frustrating, but that's the burden of proof at the preliminary hearing level. It is
Thank
what it
you.
is.
Thank you. The same question to Dwayne Fisher.
Again, I agree with Olga on that. That is the level. It's the basic premise is that a crime has been committed and that reasonable evidence is there to show that this person committed the crime. That's what you have to show at that level in order to hold it over. It's not proof beyond a reasonable doubt. It's not, the trial's not occurring at that time. It's just that much information that you have to look at to see if that very low burden is met in order to hold it over. Now, you do have to take in consideration the rules of evidence. Did the police get everything correctly? Is everything, are all the boxes being checked that this looks just? But it still is a very low bar. You can't go too far down the rabbit hole while trying to just get it to that level to go to the Court of Common Pleas.
Thank you. The same question now for Hillary Wheatley Taylor.
Well, I don't think I have anything further to add. The standard is the standard, which is a prima facie case. And to expand on Dwayne's statement, you know, it's important to take into consideration the credibility of the witnesses and the admissibility of evidence presented in determining whether or not some evidence that this defendant committed the crime charged has been proven.
Okay, thank you. Now we're going to go on to the next question, and we're going to start with Dwayne Fisher. What are your views on the need for more diversity on the bench and the manner in which the judicial system treats members of different races, sexual orientation, or handicapping conditions?
Well, I think diversity is always a good thing. I think we should explore every opportunity to increase diversity whenever possible. I don't think anybody should be restricted on any criteria or classification other than their qualifications. Are you fit to sit for the job? Do you have the requisite experience? Or in this particular case, the training and number of votes to sit for the job, frankly. And the question is going to be, who do the people believe in? Who do the people trust? And that should not be decided upon based on race, gender, your religious belief, anything like that. Diversity should be encouraged at all points, and never ever, people should not be targeted because of a specific classification or descriptor that falls behind their bio.
Thank you. The same question now goes to Hillary Wheatley Taylor.
Maureen, would you mind repeating the question? I got the first part, but I feel like there was a second
Okay.
part to it that I
No
missed.
problem. What are your views on the need for more diversity on the bench and the manner in which the judicial system treats members of different races, sexual orientation, or handicapping conditions?
Thank you. I think it's imperative that we have a diverse bench. Diversity of race, gender, experience, socioeconomic status, and familial background are important and provides for a kinder, more compassionate, more fair, and more reflective bench. The bench should reflect the community in which it presides. As it relates to how the courts treat members of the community, I think for far too long, we've known that the justice system is not blind to race and gender and wealth and immigration status and sexual identity. And it is imperative today that those of us running for election acknowledge those disparities and do what we can within the confines of our role to help bring about the changes needed so that we stop marginalizing so many members of our community and allowing a justice system to disproportionately impact marginalized members of our society.
Thank you. The same question now to Olga Salvatore Manning.
I don't believe that anybody, race, gender, sexual orientation, anyone should be discriminated against. I think the bench should reflect the world as it is. But I don't believe that just because you are part of this marginalized community that you should therefore get a job or be elected or be put on the bench just based on that. I think we all have to keep in mind that diversity is not only that, diversity is diversity of thought. So if you have an entire bench that represents the race, the creed, the sexual orientation, and anyone out there, if everybody thinks the same, it's not diverse. You need to have conversations. You need to have confrontations. You need to focus on different ideas. If everybody agrees, what's the difference? So for me, it's diversity, yes, equal representation of everybody in the population, but it also has to be diversity of thought. I think we all need to think a little bit more, argue a little bit less, and allow everybody to voice their views and listen to each other.
Thank you. Now, with this next question, we're going to start with Hillary Wheatley Taylor. Please name a judicial role model and explain your selection.
Sure, I'll repeat the answer I gave in May, which was Judge John C. Euler, the person who gave me my first job after law school. He was a York County Court of Common Pleas judge assigned to the Orphans Court Division. But as luck would have it, my term as his clerk included 2 murder trials that garnered national media attention. And so what I thought was going to be a clerkship of parental right termination and adoption and estate accounting turned into one of the greatest educations in criminal trial prosecution and how to manage multiple lawyers, multiple defendants, national media attention, bringing juries in from out of county, and ensuring an efficient running of the courtroom. And if I learned nothing else from Judge Euler, it was that the time of the litigants and the participants is more important than the judge's time. That means you take the bench when you're scheduled to arrive and you work your full day to ensure that you have judiciously used the judicial system and taxpayer money.
Thank you. The same question now to Olga Salvatore Manning.
Well, I'm a little biased here, I have to tell you. For me, it's President Judge Emeritus Jeffrey A. Manning. I mean, there is nobody like him, and there never will be another judge like him. And it's not just because of his mastery for the law, but it is for trying high-profile cases in Allegheny County. But it's because of his 33 and a half years of public service. Now, he, on a daily basis, was not only concerned by the cases that were in his courtroom, but in the system as a whole. He pioneered the Phoenix docket in order to make misdemeanor court and release the docket and get cases to be processed through the system much more efficiently and effectively. He's dedicated his whole life to the entire system, not just the criminal division, which he spent all of his career, but just making the system as a whole more cost effective, more efficient for the defendant, to make sure that people don't spend the entire day in the courtroom. I mean, he's just dedicated 33 and a half years to public service, and awe him every day. And I think he's a role model to judges everywhere.
Thank you. The same question now to Dwayne Fisher.
Thank you, Maureen. And I would recognize that both the other candidates have had excellent examples. Being a son of York County, I'm quite familiar with Judge Euler, and I've been before Judge Manning back in my law enforcement days. But I will focus and stay consistent with my answer from May or April, I guess, when we had our last debate. And I believe for this particular position, my role model is Blaise Laratunda. Blaise was a member of the community. As a police officer, he worked to serve the community fairly, justly, and make people feel like they were getting the best service. As a judge, he did the same thing. There's countless stories out there as I talked to people going door to door, that they didn't always agree with the decision that Blaise rendered, but they thought he listened to them, he thought he was fair, and they thought they took the considerations that they had in the courtroom that day as part of the case and made his decision, regardless of however it turned out. They had their day in court, they were heard, and their opinions were considered, even if they didn't get the answer they wanted. And so my goal would be to be like Blaise, to continue the community court, to try to solve problems here in the community at the lowest level whenever possible, and not burden the court system downtown with things that we can handle here. I think it's important that this judge be a facilitator, not an activist, and be one that tries to help the community and the individuals equally.
Thank you. The next question, we're going to start with Olga Salvatore Manning. Please describe an ethical dilemma that you faced and explain how you addressed it.
Ethical dilemma involving myself or observing? I'm not quite sure what the question is asking.
Your choice. Any dilemma that you have faced in your life personally or professionally, and how you've resolved it.
I think the only example I can give is practicing criminal defense. A lot of times you'll have clients that come in and tell you about the situation and explain to you more than what's in the affidavit. And then further down the line, when you get to trial, the particular defendant wants to take the stand and say something completely different than what they told you in your office. So for me, in my career, it's usually been not to suborn perjury. And therefore, there are ways in which you can inform the court that you either have to step aside or you're not going to represent the client if they decide to take the stand. But that's probably the most difficult dilemma that I've experienced, is the suborning of perjury.
Thank you. The same question now to Dwayne Fisher.
Thank you, Maureen. And I would say in my career as a law enforcement officer, I think everybody's aware that actually you raised the question earlier, is there an unfair advantage that the police have in the courtroom based on familiarity or any other reason? I think as far as facing issues, I've faced it at both departments that I've worked in most recently, where everybody thinks there's this code or blue silence where we protect the officers. And I will tell you wholeheartedly that nobody hates a bad cop more than a good cop. And in both places, I have been involved in investigations that resulted in officers leaving the job for the betterment of the department, the betterment of the services society got. And I would say it's an ethical dilemma on the outside, maybe to you or other people that see it as, man, I might be, tough to talk against my own. It was not an ethical dilemma, though it could be perceived that way, because what's right is right. I'm in this position, and I look to be in the judicial position to do what's right for the community, for the individual, and I will continue to step up in uncomfortable situations and call people out when they are not doing what they are supposed to, if they're not doing it the right way or for the right reason.
Thank you. The same question now to Hillary Wheatley Taylor.
I think I'm going to repeat the answer I gave in April when I describe a situation where I was faced with whether to report a colleague for a violation of the rules of professional conduct, which we're obligated to do as lawyers. When we experience violations or know of violations of the rules of professional conduct, we have an affirmative duty under the rules to report that to the disciplinary board for investigation. And yet, who am I to judge whether or not someone has violated the rules? And so I was faced with that dilemma of who am I to judge versus I have this affirmative obligation. And the way I dealt with it was by calling Judge Euler, who served on the Judicial Conduct Board and has been a benchmark of ethical conduct my entire career, for advice. And I followed his advice and felt good about the decision we made together.
Thank you. Now, this is going to be the final question before we go to closing statements. Can you tell us who or what the major influences in your life have been? And we are going to start with Dwayne Fisher.
Major influences in my life. Well, first and foremost is my parents. They were fortunately are both with us still. They were up this last weekend to attend the Steelers game with me. So I'm very happy to still have them and have them be strong influences and sounding boards. We started out with a very modest beginning. I am not a kid that was born with a silver spoon in my mouth by any means. And I learned how to work hard to get where I wanted to be. I was the first one on either side of my family to attend college. I was the first one to get a master's degree. And it was something that stemmed from my parents to study hard, work hard, do the right thing, and you will get ahead. Professionally, I will give credit to, and hopefully he sees this, Lieutenant Tom Gianni, who was very instrumental in my career as a law enforcement officer here in Mount Lebanon. He guided me very carefully, gave me good advice, stood by his men, but expected them to do right and called them out when they did not. And the last person I would go back to is my college professor, who's unfortunately passed, Dr. Bob Denoncourt. He was an incredible man that taught me to look at things from different perspectives, explained how you can address things from many different levels, and gave you a great perspective on life and how to move forward and just champion every day.
Thank you. The same question now to Hillary Wheatley Taylor.
I'd be remiss to not mention my parents because I wouldn't be sitting here but for them. They're the reason I have values of hard work, kindness, and I have a professional drive that I attribute to them. And frankly, the other person that's had the biggest influence on my life recently is my 9-year-old son. He is the reason I am on the path I'm on these days. And he has shown me a new way to look at the world and has made me think towards the future in a selfless way that I may not have had the approach to if not for his arrival in my life. And I'm working hard and want to bring fairness and transparency to the court system to give him a justice system I think he and all the kids in our community deserve.
Thank you. The same question now to Olga Salvatore Manning.
Well, of course, it has to be my parents. I think they gave me and my sister an incredible foundation that was based on family values. It was based on treating everybody like you would want to be treated, be kind to everybody, because you never know when you're going to need somebody. And I think over the course of my life, it's all come to be lessons that came true. They instilled the importance of education. They weren't really super strict, but told us that with an education, that is something that will lead the breadcrumbs to a successful path, which led me then to go work for Westinghouse for over 13 years, and then following that at the age of 35, moving on and going to law school. But without that foundation, I wouldn't be here. My mother's a professor at the University of Pittsburgh, and my father was a nuclear engineer for Westinghouse. So it kind of followed in both of their footsteps. So I was very blessed to have a wonderful family that instilled those values in me, and I hope I can pass them on to my stepchildren and my grandchildren.
Thank you. And now we're going to go to closing statements, and we're going to go in reverse order from the way we started our first question. So Hillary Wheatley Taylor, go ahead.
All right. Thank you, Maureen, for moderating. And thank you to the League of Women Voters for hosting this forum and for the work that you do in our community. Thank you to Dwayne and Olga for this kind and civil forum tonight, and for running. This is hard work. And I thank you for putting yourselves out there for the betterment of our community and the judicial system. Since I announced my candidacy in December, I've worked hard to understand what Dormont and Mount Lebanon need in its next magistrate. I've campaigned with an eye towards the future, looking ahead while understanding where we are and what we can be, and how our local court can play a role. What I hear is that we want a magistrate that focuses on accountability and recovery rather than punishment and retribution. We want a court that is community focused and understands the role it can play in creating a more fair and equitable system for everyone, regardless of race, gender, sexual identity, immigration status, wealth, or disability. Because I'm an experienced lawyer, because I'm a trained mediator and arbitrator, because I'm a dedicated and reliable, trusted community volunteer, because I'm a parent raising a young child here, because I'm willing to listen and talk about the issues, both good and bad, in our communities, because I promise to be fair but firm, and because I find that you represent the values you want to see in our community's court. I hope you decide I'm the best candidate. I'd be honored to have your vote, but whoever you choose, please vote on November 2nd. Thank you.
Thank you. Now, Dwayne Fisher, your closing statement, please.
Thank you, Maureen. My position doesn't change, though I'm still in the middle, but that's a good thing to be. And I want to thank Hillary and Olga for participating in this, and again, being civil. I've noticed, unfortunately, that politics is not always a nice place to be. And I'm thankful that we're being civil and we have this opportunity. Maureen, Preston, Judy, everyone that's helped put this together, thank you so much for this opportunity. I think everybody's, for the most part in this community, knows who I am. I've been a police officer here for over 20 years. I've been a resident for 23 years. I chose to live here when I didn't have to. I have family here. This has been my home. People want a justice who's fair, is equitable, and knows the people. That's me. I've come to their homes. The only difference in this situation now is the problems are going to be a little bit more calmed down, and they'll be brought into the courtroom. I'll be the same guy that I was when you had a problem with your kids in school, when you had a problem with family members or neighbors, when you needed guidance on situations, whether it was an issue with a code enforcement or traffic or law or a PFA. I'm still going to be that guy that's out there in the community, just like I was when I was on the bike. I need your vote to get in that office. Like Hillary said, though, get out and vote. Whoever you choose, exercise that right. That is so important. I humbly ask for your vote to be the next Magisterial District Justice in Mount Lebanon and Dormont.
Thank you. Olga Salvatore Manning, your closing statement, please.
Thank you. First, I would like to thank the League of Women Voters for hosting this forum, Hillary and Dwayne. This has actually been kind of fun. I was kind of nervous, but this was pretty fun. To all the residents of Mount Lebanon and Dormont, it would be my honor and privilege to receive your vote. I'm running for Magisterial District Judge because I believe that my professional experience as well as my life experiences make me the best candidate for this position. 15 years of practicing criminal defense and being a family law practitioner has exposed me to clients in their most vulnerable states. It's always been my responsibility to ensure that all of my clients' rights are protected and that their case is resolved in a just and honest manner, no matter what circumstance they would find themselves in. I have extensive experience dealing with clients with mental health issues and with addiction issues. And I know the system very, very well and how the system addresses these issues. And I'll be able to help them from the onset, from the magisterial district level to proceed. It's this cumulative experience that I have that will make me an unbiased and open-minded magisterial district judge. I'm nonpartisan. I don't have an agenda. If I'm elected, I promise that every voice will be heard. I promise that I will treat everybody with respect. And I promise to take each individual case and preside over it equally, fairly, and impartially. Thank you so much for your consideration.
Thank you very much. On behalf of the League of Women Voters of Greater Pittsburgh, I want to thank all of you for participating in this forum. I'd also remind the voters who are watching that you can obtain information about all the races on your ballot by going to vote411.org and entering your street address, and the ballot for your specific area will appear. Please remember that Election Day is November 2nd, 2021, and polls will be open from 7 a.m. to 8 p.m. You can still apply for a mail-in or absentee ballot by October 26th, 2021 by going to vote.pa.gov. Mail-in and absentee ballots must be received by the County Election Department by 8 p.m. on November 2nd, 2021. I'd also ask you to visit our website, lwvpgh.org, for all types of information on the upcoming election. And I want to thank you all once again. This forum is the property of the League of Women Voters of Greater Pittsburgh, and it can be found in its entirety on the League's Facebook page and also on our YouTube channel. Thank you very much for your attention.